But family, this is breaking news out of Atlanta, Georgia. Nature Boy, a.k.a. Elijah Bishop, a.k.a. Nature Boy, has been found guilty on all charges. It's a real nigga moment.
Count 1 was adjourned. Count 3, guilty. And count 2, false imprisonment, guilty. Count 3, prohibition on user sexually explicit electronic transmissions, guilty. Count 4, prohibition on user sexually explicit electronic transmissions, guilty.
Hundreds of thousands of people lost their lives. And when we, the difference is we have COVID protocols to prevent the spread of COVID. And one of the protocols were like negative tests. Before we could even open things, we needed negative tests. So the idea that although preventative measures were done afterwards, he as a defendant on a trial for his life has absolutely the right to ask for a postponement because you don't know his story. We don't know how COVID can affect him. We don't know if he has a respiratory issue. We don't know if he visits people in jail. There's so many things that we're not considering, and I think that it should have been for the purposes of judicial economy, because I think that he has a very good appealable issue that court should have stopped.
This man is doing everything he can to delay the trial and or get a new judge on the trial. That's obvious. But I think in his zeal to do that, as Eklund kind of touched on, he might have pointed out a really important issue. He might have highlighted something that could get his case overturned, because I cannot think of, and this is going to be an issue, I think, of first impression, right? When is a defendant's health and safety and possible life being put in jeopardy by the judge that's presiding over his case, right? So his choice is possibly put himself in jeopardy and or not attend his trial. And in that regard, I think Eklund is spot on. The judge should either delay the trial until she's test negative, what have you, because she's putting all the health of all these people at risk. And I know if I was the defense attorney, I certainly wouldn't want to be there under those circumstances. I don't know that if counsel has voiced that or not, but yeah, in his zeal, he's stumbled across what I think might be a legitimate issue.
And echoing what Eklund and Kirk said, if you're the judge here, and I know the CDC guidelines have changed a little bit from 5 days to 24 hours, but you really want to make sure that these cases are bulletproof on appeal. Sometimes judges just want to move forward, especially when they're frustrated with the pace of a case. They don't want to waste the jurors' time. But, putting this case on hold for, a day or two, even pushing it out to next week, I think would have avoided an unnecessary appellate issue down the road.
That there was a positive COVID test negates all of that. I think that he has the defense rights itself. The fact that he also showed damage in that he didn't testify on his own behalf, because it's either testify and be subject to COVID or, be in the jailhouse and risk testifying via television. So I think that his rights were so infringed that it doesn't matter the facts at this point.
So the first thing that a client needs to know, and if you're one of my lawyer friends that watches these, you'll probably know this, but explain this to your clients when you refer them over, is when you're appealing a case, that is not the same thing as asking for a new trial or being granted for a new trial. What I mean by that is an appeal is not something that you can use to show a bunch of new evidence to the appeals court that should have been shown to the trial court level or to the jury, okay? There are certain exceptions if what you have is considered newly discovered evidence, if it's some evidence that there was no way you could have possessed when your case went to trial, then you can bring it up at the appeal stage. But normally speaking, an appeal is not a place for you to relitigate whether or not you're guilty or innocent, okay, in the sense that most people think. An appeal is constrained to arguing about legal errors that occurred during your trial. So objections that were made that the judge ruled on incorrectly, evidence that should have been excluded but was admitted anyway, evidence that should have been admitted but it was excluded by the judge's ruling, jury selection issues, that sort of thing is really what you're focusing on when you're appealing a case. So along those lines, there's a couple things that you as watchers of this can help with if you're coming in for a consultation or if you're representing people who you will then refer to us to handle their appeal. First off, if you're coming in, kind of know that. So know that when I'm telling you and I'm giving the answer that, look, I understand that you think this witness should have been called, but your lawyer didn't call them, there's not much I can do about it on appeal. So just kind of understand that and know that that's not me telling you you have no right to try to argue that point. It's just not going to go anywhere. And then second, if you're a lawyer, make sure that if you're taking cases to trial or if you're in contested hearings, be they an open plea or a sentencing hearing or something like that, preserve everything. Preserve errors, even if you think the judge is getting them right. Even if you think it's a long shot that we win this objection, make the objection, because it gives us so much more wiggle room to actually file an appeal and have an issue to present when we have these objections that were ruled upon, that we can then argue there might have been a legal error. Because it might be an error that you are unaware of, that the judge is unaware of, that the prosecutor is unaware of, but because there's this new case law out there, this case that nobody was aware of at the time, we're able to bring that issue up on appeal. But if you don't make the objection, if you don't preserve that error, then that stuff just gets waived. And unfortunately, we have to tell these clients that there's just nothing we can do to help them. So if you're a lawyer, make sure you're preserving that error. If you're a client who wants to take your case up on appeal, it's certainly something that we can help with. Just know that we're going to be limited in the type of relief that we can look for. And we'll go over that with you in detail as to what we can and can't do. But I wanted to kind of give you some background because there has been a lot of miscommunication and misconceptions about what an appeal actually is.
Hey yo, if you enjoy this content, please support the channel at... And oh yeah, don't forget to follow me on all my social media platforms, especially Rumble, because I can put content on there that I can't put on YouTube. So please support that. I will put my beacon link in the description box. That way you can follow me on all social media, Discord, Facebook, web, Twitter, wherever. You can follow me wherever. Please support the movement. CV Killer forever.